Hi, I'm George Whipple. This is Employment Law This Week, and here's what you need to know. The threat of COVID-19 is growing, and U.S. companies are on high alert. International travel by employees is an area of particular concern to employers. CDC guidance recommends that employees check the agency's travel health notice for each country before traveling, and not travel if they are experiencing acute respiratory illness. In an abundance of caution, many companies are pausing all non-essential business travel outside the country. Knowingly sending an employee to a conference overseas, particularly to an area that presents a reasonable threat of infection, could expose an employer to liability for failure to provide a safe working environment as required by OSHA. Even though there are currently no restrictions on domestic travel, some employers are making national conferences and event travel within the U.S. optional. For more, check out our resource center at ebglaw.com/coronavirus. The NLRB has published its final joint employment rule. First proposed in September 2018, the rule resets the standard for determining joint employment to one used by the board for 30 years until the controversial 2015 Browning-Ferris decision. Effective April 27th, the NLRB's new rule classifies a joint employer as a business that exercises substantial, direct, and immediate control over another employer's workers. Finally this week, a federal judge in California has ordered food delivery company DoorDash to conduct over 5,000 individual arbitrations on claims that it misclassified drivers as independent contractors. The company required its employees to sign an arbitration agreement containing a class action waiver, a practice that the Supreme Court endorsed in its 2018 Epic Systems decision. Despite the waivers, DoorDash refused to pay the arbitration fees in an attempt to force the cases to court where they could be resolved as a class action. But the judge held that the agreements bind both the drivers and the company to arbitrate the claims individually. Under California law, DoorDash is now required to pay most of the fees for the court-ordered individual arbitrations. It is estimated that that could cost the company well over $300 million. And that's what you need to know this week. Thanks for watching. We'll see you next time.